Greetings, greetings.
Greetings, King. Good to see you.
You look, like I said, beautiful, beautiful.
Well, thank you. I'm a little technically challenged, but I'm working on it.
It's okay. It's all right.
I'm
It's
gonna
all right.
turn my sound
Let me
up.
know when you're ready.
Okay, the mic's on. Oh, then- okay. Can you hear me well?
Very well.
Okay. All right, one moment.
All right. Just let me know when you're ready to go.
Okay, one second. I'm just gonna turn the sound up. Okay.
Okay.
All right,
That,
I'm ready.
okay. All right. So let's get started. You got your microphone down on your phone.
I'm on my computer. I can make it lower.
Yeah, just we don't get no feedback, no drag back.
Okay.
All right.
All right, I think I'm okay. All right.
Greetings, 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 greetings. It is I, King Clifford Jefferson, our Senator Godfrey, the fifth kind of band Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know as Jesus Christ, the King of Peace, or Melchizedek. It is July 15th, 2025, which is equivalent to the birth year 2975. We give honor to our ancestors because it is in fact, it is indeed the glorious day in honor of the Magna Carta. I give honor to my queen, Sister Galveston from the House of Galveston, as well as my co-host, Sister Middleton, or Countess Middleton from the House of Middleton. You can give your greetings, Countess Middleton.
Greetings, my Lord and King. Greetings, all members of the King's Bench. Greetings to all that are partaking on this meeting and are supporters of the Third Temple Church.
You're breaking up a
It's
little
very
bit.
good. It's, uh,
You're
it's
breaking up.
lovely to be here.
Fine, you're fine now.
Okay, so it's very nice to be here. As usual, King, it's very timely that you are having this meeting in light of all that's been going on in the world and those are trying to get rid of the king, as they had an event yesterday. So I'm sure you'll get into that as well.
Yes. You digress?
And I digress.
Well said. Once again, I want to give honor to all the family of the Third Temple Church of England, as well as all of the ancestries, our children, our ancestors, our predecessors, all of our noble peerages of English, Anglo-Saxon, Berber descent. We want to give honor to Brother McGarrett as well today for showing up today. We have a marvelous lesson prepared for you as well. Without further ado, let's get started with this marvelous lesson. I have a couple of thumbnails that from TikTok that I'm going to show, as well as I'm going to show a couple of pictures, but it's going to really be a deep conversation today about landlords, land tenures, land ownership. We're going to show how land is acquired unlawfully, how it was really supposed to be acquired lawfully. We're going to talk about a lot of things, and all this has to do with going all the way back to the Magna Carta and the First Baron War. Okay, it all goes back to the First Baron War when John was forced to sign the Magna Carta as a result of 25 royal barons, or what we call feudal barons. This is what you call landlords today. Okay, so I want to give you too much, so please hold on to your seat because this is going to be a wild ride. So I'm very excited about it today. So if I stumble in my speech, please forgive me. You know, I stutter, but we all know as humans we have some sort of human defect. But as gods, we're divine beings, and today the lesson is for the divine beings. With that being said, let's get started with this marvelous lecture. I got Countess Middleton here. She's going to read for me as well as be able to give her narrative, as well as I'm going to be able to expound on what it is that we're talking about today. But for the starts, we're going to go into a couple of videos, and the first one I'm going to play is from Archbishop Belmont from the English Episcopal Church of England. I want to give honor to him in regards to the post, in regards to the topic today, in regards to the Magna Carta, how the Magna Carta assists us, as well as how the Magna Carta was used unlawfully by those who were not of our lawful parentage. Okay, that were not of our nobility. We know that the Constitution of every state does not grant title of nobility. Okay, very important of why that clause is in the Constitution. We're going to talk about that today. Once again, I also have to remind myself that I talk fast. I'm going to have to slow it down a little bit so that the lesson can be clear. So with that, let's get started with this marvelous lesson. Okay. Archbishop does just a beautiful job with the internal and external affairs of the church. So I want to give honor to him. We all should give honor to him for the illustrious work that he's doing.
Indeed.
Peace and love, brothers and sisters. And I have to say, happy anniversary to the greatest, most magnificent, magnanimous charter that ever existed here on the earthly plane, especially here in the territory that you call America, as well as England, and that is the English Magna Carta. The Magna Carta was signed June 15th, 1215, in the territory that we call Runnymede, by King John I from the Royal House of Plantagenet with his disgruntled barons. And these disgruntled barons actually forced the king's hand. So, anything that's pretty much done by force is considered coercion or threat and duress. So what the king had to do, just so that therefore he can save not only his life, but the sanctity of the kingdom, he had to go ahead and relinquish some so-called rights to these disgruntled barons. Now, why this information is important? Because if you understand what's taking place all over so-called America, which historically is underneath, which is still underneath the jurisdiction of the Kingdom of England, even though the people don't know it, they're doing the so-called No King's protests. Now, the problem with this is in 1783, the King of Great Britain went ahead and signed the so-called Treaty of Paris that gave you the ability to exist as a free sovereign entity or a free and sovereign nation. Now, what the king was doing out of his gracious, because he didn't actually have to relinquish his control of his colonies for you to actually be out here doing your monopoly or your commercial enterprise. And so now many of you folks today who are actually citizens and wards, who are actually the descendants of those people who was in rebellion in 1780s, are actually nothing more than doing what they did back then, regarding, like I said, trying to come away from the king, which placed you in the position that you're in today as debtors. Slaves in bondage perpetually, because you came away from the king, and the king back then was known as the Vicar of Christ, especially in the British American territories, what we call the United States today. So for those of you in America who don't know, the 1783 Treaty of Paris, which gave the United States the ability to exist as a free and sovereign entity, you need to not only do your homework, but you need to settle down and understand who you are on what side of the fence and what parties, because you still owe your position in regards to upholding that treaty of 1783, which was signed and passed by a king. Peace.
Well done, Archbishop. We're going to give honor to him for that beautiful narrative about our illustrious history going back to our ancestors, the Anglo-Saxon burghers, the ones who took the torch from the kings of Wessex, going all the way back to the Statute of Westminster of 1275, dealing with the invaders or the immigrants who migrated to England over here, such as the North Danish Vikings and whoever else who immigrated to these lands. Okay, very important that you understand that, because we're going to show the proof today. All right. So with that in mind, I'm going to show you another video in regards to the actions that are taking place today on the streets of the United States in Washington, D.C., Los Angeles, Philadelphia, are the same thing that appeared during the time of the Revolutionary War. Okay? I really think that what they told us about the time of the Revolutionary War, about the time of the colonies, I really think that was no more than a theatrical scene that's actually playing out today. Okay? I think it is a theatrical scene that's actually playing out before our eyes. So, our brothers and sisters, whether you know yourself or not, please stay out of the mess that's going on. All right, because it's called defamation per se. Once again, it's called defamation per se. Slander and libellous. You know what that means? To slander somebody is to talk negative or harmful about them. Rebellious is to write something or to publish something or to print something that's harmful to somebody. These are violations of law because they are biased. Okay? They are biased. So the actions of the citizens today to their so-called autonomous government under the leader of that government, what they call Donald Trump, is called defamation per se. We're going to talk about that because if you continue on with it, you're going to find yourself in a world of trouble. Okay? My brothers and sisters, stay out of it. Let's play this other video. This is from Brother Nunnally, from the house of Nunnally. I want to give honor to Brother Nunnally for the courage to be able to understand what's presented before him. I didn't even see this till Archbishop brought this to my attention, so this is the reason why I want to play this as well. Good evening, Archbishop from the house of Belmont. Glad you were able to join us today. All right, we gave honor to you as well as Brother Nunnally for your diligence and continuous search for the truth. As we see, Brother Nunnally has found truth based upon the information that he received here at the Third Trinity Church of England. Let's play it. Greetings, Bishop Murphy, Archbishop Part Self. Greetings, Brother Murphy from the House of Murphy. Let's play this.
And do the time come for them.
Share this. Thank you, Bishop Murphy. Here we go. Everybody listen very closely. No more king.
Take command. It's very clear your face on thinking no matter what you say, we won't obey.
Can you hear that?
And we're gonna run it all away with no more king. We're gonna elect a president. No more king.
Can you hear that, Countess Middleton?
Yes, I'm going to turn it up a little bit.
Let me see if I can do that.
And knew the time had come for them.
Let me see if I can put the volume as high as it go on this. I think
Okay,
as high as
that yes,
okay.
It's fine. It's fine.
Okay.
To take command. It's very clear your face on thinking no matter what you say, we won't obey. Gonna hold a revolution now, king, and we're gonna run it all away with no more king.
We're gonna elect a president.
No more king. He's gonna do what the people want. No more king.
We're gonna run things our way.
No more king. Tell us what to do. Rockin' on the moon, session, slashing over the horizon. Where can it be? Looks like it's going to be a free country.
Now, if you come across this video, if you're able to actually see it on TikTok, the language in the video is pretty much saying what the founding fathers were saying at the time of their Declaration of Independence from Great Britain, i.e. Great Britain is not England. Great Britain is the result of the Treaty of Union of England, Ireland, and Scotland. Prior to that union, there was no unification of any realm connected to England. So it's very important to understand that what the what the colonists are saying at this time and the representatives of their government are saying at this time is that they don't want no more king. So they're going to choose a president. Okay? They're going to choose a president to suit their wishes for their government. That's not the government that was already here prior to their establishment of their government. And that government prior to 1707 was, in fact, the Kingdom of England, called the Crown, His Majesty's Council. Okay, we're going to show you the concrete proof today, but it just shows you that they already knew their undertaking was headed for destruction. Okay, because the same thing you see in this cartoon, going back to the Declaration of Independence, you see the same thing happen now in 2025. This is called defamation per se. Very, very, very important because Trump never said he was a king. You can't show me nowhere that Trump ever said he was a king. Y'all calling him a king. He never said he was a king, but his actions dictate that of a king. Y'all are upset about that, but that's what y'all chose. You said that you're going to choose a president, choose a president to best suit your wishes. Okay? That's what you said. But now all of a sudden you're upset with the president because he's not undertaking the undertaking that was done at the time of their founding. He got a whole new argument now. He said, we like kings. That's what he said. He said, we like kings. Let's see. You don't believe me? Let's hear it for ourselves. Everyone better listen. Well, you think this is revelation? He's that trumpet that's blowing. He's letting you know what's coming. All right, he's that last trumpet. All right, he ain't the king, but he's blowing that trumpet and letting you know the king is coming. He's letting you know that the King of Kings and Lords of Lords is coming. The one you call your Lord and Savior is coming. He knew it. Let's see. It's showing. Okay, here we go.
It's not really feeling it. World War III, folks. Hard pass. We've got enough going on stateside. Got the No Kings riots set to kick off this weekend. No Kings. We like kings, actually, folks. We like one king in particular, quite frankly. The King of Kings, our Lord and Savior. I don't know. Maybe you've heard of him. With that being said, just not really feeling it. World War III, folks. Hard pass. We've got enough going on stateside. We've got the No Kings riots set to kick off this weekend. No Kings. We like kings, actually, folks. We like one king in particular, quite frankly. The King of Kings, our Lord and Savior. I don't know. Maybe you've heard of him. With that being said.
Okay, you heard it for himself. He ain't got a problem with the king. Did you hear him, Countess Middleton? Did he say he got a problem with the king?
No, not at all.
He said he ain't got a problem with the king. He like kings, okay? But that's not the argument that y'all was saying at the time of the founding fathers. One second.
In the outfield, honestly, like literally when I'm in the outfield, I'm talking to God the whole entire time. Like I think that's what keeps me going. I love the game of baseball because you fail.
That's
so
not
much.
what y'all was saying at the time of at the revolution. You said you chose a president, right? You didn't want a king. No more king. That's what y'all said. Y'all didn't want a king. You chose a president. All of a sudden now, your president's talking about he ain't a king, but he like kings. You really need to look at what's saying because he works for the king. Why would he say that? He's an officer just like everybody else in the government, are officers of the crown because the king represents the crown. It's one office. It's one tenure. Okay? The king is a true landlord. If he doesn't give you a charter called a land tenure, you cannot call yourself an owner. Okay? You cannot call yourself an owner. You cannot call yourself a landlord. Okay, he said Jesus was King of Kings and Lords of Lords. So if anybody's the owner of the land, then it's him. Okay, so let's view that real quick. All right, because a lot of us have a hard time understanding the language, the English language. You're speaking English, brothers and sisters. Okay, you're speaking English. This comes from the pleading act of our ancestors, Edward the First. Why? As a result of what happened in the Norman conquest, when the Normans, the Franks, the Spanish invaded England right here on this soil. Before you had any sort of real estate, because real estate are just the houses, the buildings, the complexes that were here. But check this out, prior to them coming here in North America, there was no concrete houses. There was none of that. Why? Because there was nothing but forests. Okay? Forests, but they cut those forests down to build what? Cabins. We didn't build cabins. We built castles out of bricks, so we didn't have to clear the forests. We already knew what we needed to build our establishments, castles. So we realized that what they did when they came over here, they cut down the trees and used it under what they call the Industrial Revolution. That's subject to what we call waste law. Changing the property from the original owner. That's what you're doing. You're changing the property and you're bringing down the property value. That's called waste law. Very important because we're going to talk about it again today. First, let's deal with the term land, real estate. Okay? Land, real estate. When we say land, we're not talking about real estate. When we say land, we're talking about estates and land, brothers and sisters. Estates and land. Because the land is the trees, the bushes, the grass. That's called land. Okay? Estates and lands and everything associated with land. The subsurface, the air, the water rights, okay, those are called estates and lands that your ancestors preserved for you before they start building houses. Does that make sense, Countess Middleton?
Absolutely, King.
Okay, let's go on with this. So let's go back in time before the colonists even got here, and just look at the land before they got here. Straight land. Just get a visual view of our ancestral estate before we even get to talking about real estate. Because in order for real estate, you must have a landlord. Okay? You must have a landlord because real estate is the business of conveying property, real estate. The landlord to the tenant. Okay, so let's get a visual real quick. Picture speaks 1,000 words. You got your coffee, Countess Middleton?
I didn't get my coffee.
Go ahead.
But it's okay.
I'm going to
Take
warm
a few
mine up.
minutes.
Yeah, go. I'm going to warm
Okay.
up. Go ahead and get yours. You're going to need it. We advise
Okay, good.
coffee too if you got some.
Okay, good.
These are the basics, brothers and sisters, that we know here because we're home. If you home, this information you must know. Well said, Archbishop. 1776 to 1783 is now 2024 to 2026. Well said, Archbishop. If you think you have an inheritance here in what we call now America, you better be watching this lesson today. The Magna Carta, June 15th. That's today. No coincidence. Anniversary. Why? Because those royal barons stole your land. When we say those royal barons, we're talking about those landlords, okay? The lords of the manors, okay? Those barons, the ones who sell you your real estate. That's who we're talking about today. These are assumed to be your landlords. While we wait for Countess Middleton, are there any questions? Please ask now. Are there any questions? Please ask now. This is what you see here. You see what we call real estate and estates and lands. Real estates and estates and land. Where you don't see realty sitting on, those are called estates and land. Where there's just nothing but the land there. You call them parcel estates, okay? Most Americans call part and parcel, but they're called parcel estates or estates and land, okay? Or a lot and block. When you look at the so-called deeds, you see what they call a lot and block, okay? So this is actually what you're talking about. This is the land, okay? Before you see the houses, okay? All this real estate sitting up there, this was nothing but land, trees, etc. Very important to understand that, okay? And at this time, there were people already here living in castles, okay? Before they knocked that down and start cutting down the trees and building log cabins and stuff like that. Very important to understand that, to understand where we're going. Because we can't go to where we come from if we don't know how to get there. So these are parcel estates or estates and land. Before any realty is sat upon it, which you call real estate. Okay? Thank you, he who is. Real estate. Real estate. And wait for Countess Middleton. I want her to miss this picture. Now, as we just seen from the videos that we just shown you, that when the colonists got over here, all right, when they got over here, there was already a government set up, okay? It was already functioning government set up. Before the colonists even got here, there were other immigrants immigrating over here. When you go back to history before America and Scotland, you deal with Spain and France. So you need to know all this history. Okay? And in the history of Spain and France, you didn't have log cabins back then. When France and Spain colonized North America, there were no log cabins back there, brothers and sisters. They had castles. Where did they go? The Olmecs wasn't living in no huts and mounds. Okay? How come the Aztecs and the Mayans all of a sudden got ziggurat temples and mount made out of stone? Okay, very important. We are the forefathers, the Olmecs, the old Mexicans, the mound builders. Okay, they wasn't building mounds with wood. Come on, make this make sense. So what we're looking here, before the colonists got here, or any person that's not indigenous to this land, okay? If you're not indigenous, you don't have the right to be here, okay? Nor do you have the right to own property here. Nor do you have the right to enjoy any of the rights that have to do with the inheritance of an estate that was granted to you by the Lord God Almighty, okay? The Lord God, the one who looks just like you and talk like you, because he told you. You're reading this very language. This is the English language. That meant that God was an English man or an English woman. Okay? Very important. So what we're looking here, Countess Middleton, is a parcel of estate, which is sitting on allodial land without any realty sitting on it. Because when you got realty, that deals with real estate. Estates of land does not deal with real estate. It just deals with the land, the subsurface under the land. That means minerals, gold, silver, carbon, whatever. Okay. Then everything above the earth, as well as water rights. These are called littoral rights and revenant rights. When you're talking about a small body of water or a large body of water, all this is called it's called a radical title of the crown. It's called overseas possession. Very important. So you see a picture of what we call a parcel of estate on allodial land, and just think about it being allodial or parcel of estate without any realty being on it, i.e., real estate. Okay, very important. Because when you're dealing with real estate, you have to have a landlord and a tenant. So the question becomes, who is the tenant and who is the landlord? Because from what you look at the English language, the word said Lord, right? It says landlord. That means the Lord of the land. Then you got land tenures. So if the Lord is the Lord of the land, then he's the one who's able to convey what? The land tenure. Okay, to whoever it is he gives it to, which becomes what? The landowner. So the landowner, which holds all allodial land, gives the land tenure, which conveys the lands to the tenant, now which becomes a landlord, or a manage lord, or lord of the manor, or tenant in chief, whatever name you want to throw at it, it's still the same. Okay? So you must understand, how did they come into possession of the land? Okay? The estates and land. So let's look at the definition of estates and land. Rights and limitations of real property ownership. Rights and limitations of real property ownership. Read it for it, Countess Middleton.
Rights and limitations of real property ownership. Real property rights, surface rights, rights to the airspace above the land, mineral rights, water rights.
Read it for them again.
Rights and limitations of real property ownership. Real property rights, surface rights, rights to the airspace above the land, mineral rights, water rights.
Okay. Did you see anything about real estate?
No.
Not at all. Not a darn thing about real estate. So this has to do with estates and land. It didn't say estates called houses. It said estates and land. Owning land is true ownership. That's the true owner. The true landlord. Okay, very, very important to understand these terms. So if we're talking about estates and land, which is an inheritance from God, okay, whatever God you're talking about, apparently He left you some land, and in order for you to enjoy that land, is rights that come along with it, mineral rights, water rights, as well as air rights, etc., whatever else comes along with that. Okay, so it's very important. Before real estate came into the picture, i.e., what we call houses, buildings, condominiums, industrial sites, there was no such thing. Okay, now we have to look at real estate. So we have a picture of real estate. Real estate falls under what we call contract law between a grantor and a grantee. You're right, resident. Resident is the same thing as a tenant, meaning that you just reside there. All right. They tear the building down. Where you gonna go? Where you gonna go if if the building becomes damaged or destroyed? Okay, as a result of non-management, then what happens to the residents? Okay, are they going to put them somewhere else? No. Who all controls everything that goes on relative to the so-called real estate? The government. These are called encumbrances. Before these encumbrances were created, there were no encumbrances from the government. It was just nothing but the land. Okay, nothing but the land rights, subsurface rights, air rights, water rights, etc. And you still were living in some type of domicile before they had these houses. What were you living in? Because our ancestors' history said we were living in castles. All right? Very important to understand that. All right, so you see a picture. Let me show. I didn't show it. One second. My daughter's show. Okay, here we go. So you see contract law involves two parties, the grantor and the grantee, okay? Or the landlord and the tenant. Very important. Very important. Do not miss this understanding. So where did this come from? Landlord, okay? Now, landlords have to incorporate, or corporations, first of all. Did y'all know that? A landlord is a corporation because in order for there to be a landlord, you must file what? A certificate of registration on the county level with the county clerk's office. Very important for you to understand that. Okay? So you are a corporation under corporate powers. And usually corporate powers derive their authority from a sovereign grant. They derive their authority from a sovereign grant. All this is going to be discussed today. All right, so with that being said, the topic of this lecture is landowner, land tenure, landlord. Know their origin, because the majority of us do not know the origin. So this is why it's being discussed today, because the problem we have today with no king is because this is the king's land. It's the crown's land for those heirs. You are not an heir. Donald Trump has made this perfectly clear. You are not heirs. There's only three ways you can have some type of citizenship here in what we call North America. Three ways. The Naturalization Act of 1790, which only deals with the color of skin. The Immigration Act, which includes residents, national or naturalized, meaning the same thing to them on the Title 8 United States Code, Section 1401. Okay, so they're naturalized citizens are under the same status as the founding fathers because they have nothing to do with any biological connection to this land. The only thing they have connected to it is by being born on the soil. And we know what most Americans say, just because you're born here don't make you a citizen. You as a Moorish American must ask yourself that question too. Does that comply with you? Or are you complying with the right to be here on this soil as a citizen? Okay, not just a citizen born here, but a citizen here by blood, by ancestry, by genealogy, by peerage. Okay, very important. You have to be a descendant of the noble family of the lords. Okay, you have to be. This is what this all about. Going back to the Magna Carta of those landlords, which are called barons, feudal barons at that, under feudal law. That's why you pay taxes. That's why you pay taxes, because you're paying feudal duties to the landlords, which are your founding fathers. They are called landlords. Why? Let's look at it. Now we're about to get into it. Landlord. Y'all better have some pencils and pens to write this stuff down. So when you get evicted from your house through adverse possession, you'll be able to have an argument. If you're an Englishman, i.e. Anglo-Saxon Berber, if you're not, you have no right to property whatsoever. And I don't mean to say that with any negative denotation, but truth is truth. I've been saying this from day one, all right? You must understand that if you're not a child of the Lord or a descendant of the Lord or an ancestor of the Lord, you don't have the right to be on the Lord's land. You can take that in an abstract way or you can take that in a concrete way, okay? Very important to understand that. We're saying not just from the biblical perspective that we are the descendants of the Lord, but as well as from an ancestral perspective, because King James was not even the descendant of the Lord. But yet he did know about the Lords who owned the land. He's the one who wrote the Bible. Okay? And Donald Trump he's got some German, Irish, Scottish in him. Okay? And very important that he said himself that he has a Savior, King of Kings and Lords of Lords. Okay? He recognized that he was subject to some lord, and they, in fact, were kings. Okay? He's not the same president that your forefathers or the founding fathers chose when you broke away from the crown. Because you said you chose a president that didn't honor the crown or no king. That's what y'all saying. Donald Trump is not saying that. And he's saying he ain't the king, but he recognized that there should be a king here. All right? So let's read it. Read the first paragraph, Countess.
Yes. A landlord is the owner, property such as a house. A landlord is the owner of a property such as a house, apartment, condominium, land, or real estate that is rented or leased to an individual or business, known as a tenant, also called a lessee or renter. The term landlord applies when a juristic person occupies this position. Alternative terms.
Right there. So it says, this term landlord applies when a juristic person occupies this position. So what is a juristic person? Read that for him.
Okay. Recognized by law as a fictitious person, such as a corporation, government, agency, non-governmental organization, or international organization. Other terms include artificial person, corporate person, judicial person.
ETC. Okay. So the juristic person is a corporate person, or what they call a straw man. All right. Whatever you want to use, it makes no difference to us. But if you are, that meant that if you're a tenant, you're a corporation. If you're a landlord, you're a corporation. Okay. No matter what side you choose, you are in fact a corporation. Okay. How we know it? Let's prove it. Let's go to history.
History. The concept of a landlord can be traced to the feudal system of manorialism or seigneurialism, where landed estates were owned by lords of the manor, mesne lords. These lords were typically members of the lower nobility who later formed the rank of knights during the high medieval period. They held their fiefs through subinfeudation, though in some cases land was directly subject to members of higher nobility, such as the royal domain owned directly by a king, or the Holy Roman Empire's imperial villages, which were directly subject to the emperor.
Stop right there. Okay. So we see a landlord, also called lords of the manor or manage lord, is also called tenant in chief, are originated through what they call manorism or baronism. Okay, this is called English baron law or English feudal baron law. Very important to understand because these barons or these lords of the manors or these landlords were not what? Nobles. They are not nobles. Very, 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 very important. It's that they held their states through what? Subinfeudation. Now, we already know what subinfeudation is, all right? Edward the First, our ancestor, passed a law against what? Subinfeudation. Let's look at that law before we read a little further. What law did he pass to prevent the word subinfeudation? Because it said that these lords of the manors or manage lords or tenants in chief or whatever name you choose, all right, the only way they acquired their estates and land, okay, or real estate was through subinfeudation, okay, either held by a Holy Roman Empire or a king. We're not the Holy Roman Empire. We represent the kings of England, okay? And our kings passed laws against subinfeudation. Let's read what that law is real quick. Now, we talked about this already. We already know this is old information. Read the first paragraph for them.
Okay, Quia Emptoris
Yes.
is a statute passed by the Parliament of England in 1290 during the reign of Edward I that prevented tenants from alienating or transferring their lands to others by subinfeudation, instead requiring all tenants who wish to alienate their land to do so by substitution.
Stop.
The statute,
That's
along
it.
with its...
That's fine. That's fine.
Okay.
Okay. When I hold my hands up, you can stop. Because I'm not going to read the whole thing. I just want to point certain things out in reference to the laws that were passed against subinfeudation that their modern day landlords are using to justify their right to possession of property. It was not conveyed to them, they took it. Okay? They took it. This goes all the way back to the First Baron War, why John was forced to sign that Magna Carta to these barren landowners. Okay? This is what we're discussing today. It has everything to do with the Magna Carta anniversary, which is today, because this lesson is being given to the people today. All right, in regards to the land that was taken to them by forcing John to sign chapter 61 of the Magna Carta. Very important. Let's look at it. So we see Queen Pretoria passed in 1290 by Edward I, the son of Henry III, the son of, or the grandson of John, the grandson of Henry II, the son of Godfrey V, Count of Anjou, the son of Folk, the ruler of Jerusalem, the children of God. Okay, in the Garden of Eden, called New Jersey, the Garden State, brothers and sisters. Very important. All right, let's go back to landlord. So we're on landlord. We're gonna be jumping around. When you become scholars like we are here, you're able to jump around. Okay, so we're gonna get off landlord and we're gonna go to lords of the manor. Because landlord, lords of the manor, or manage lord, or tenant chief are all one and the same. They acquire their property through subinfeudation. Subjugation is the alienation of property versus the substitution of property. Because when you substitute the property or convey the property to someone else, it must be conveyed like it was prior to you receiving it from the original owner of the land, and that, in fact, will be the king. Okay? That, in fact, will be the king or the queen, whatever, who's ever ruling or sitting on the throne at that particular time. So very important. That's the difference between adverse possession, which means you take it, and conveyance, which means it's given to you. Okay? United States or the government or the colonies was not given a charter. They took it and then created their own charter. And corporations derive their power from what? A sovereign grant. So they mad at the president. President, no, he ain't sovereign, but he is the sovereign of your government. He is the sovereign of the government. So what y'all doing right now, you're going to get in trouble because that's an act of defamation per se, which we're going to touch on in a second. Very, very important. Okay? Defamation per se. We already know what defamation means. All right? We know what it means. To slander somebody means to talk about them, as well as to post that, holding up signs, etc. Now, whether you think it applies to you, based upon the situation surrounding the political affairs that's happening today, it's still going to affect you in regards to the true origin of the political affairs that are happening today. All right, you're going to be held accountable for their very actions because it causes dissent and it causes rebellion. Okay, the same thing you did back at the time of the Revolutionary War. You're repeating history. How I know it? Let's look at it. Lords of the Manor. Read that first paragraph, Countess.
Lord of the Manor is a title that in Anglo-Saxon England and Norman England referred to the landholder of a historical rural estate. The titles date to the English feudal, specifically baronial system.
So
The Lord enjoyed.
So it says specifically baronial systems concerning manorial rights, specifically, inclusively, and exclusively dealing with baronial feudal right. It didn't say English baronial. It said feudal baronial. So we need to know what baronial means. So let's touch on that real quick.
In the kingdom of England, a feudal.
One second, Karen. We're going to touch on English feudal barony real quick.
Okay.
Let me just share it. I didn't share it yet. We're going to go back to Lords of the Manor, but I want to read English feudal barony so we can get the origin of where that started from. Because we didn't own land under feudal law. We own land on what we call folk land or book land, which means charter. That's how our ancestors hold land, folk right. All right. So very important to understand the difference between English land ownership and feudal land ownership, because we know feudal land ownership came with who? William the Conqueror. All right. William the Conqueror. Let's read a little bit about this. Read this first paragraph for us, Countess.
In the Kingdom of England, a feudal barony or barony by tenure was the highest degree of feudal land tenure, namely per baronium, Latin for by barony, under which the landholder owed the service of being one of the king's barons. The duties owed by and the privileges granted to feudal barons are not exactly defined, but they involve the duty of providing soldiers to the royal feudal army on demand by the king, and the privilege of attendance at the king's feudal court, the magnum concilium, the precursor of parliament.
Stop right there. Let's go here. creation. Read the first paragraph.
William the Conqueror established his favored followers as barons by enfeoffing them as tenants-in-chiefs, with great fiefdoms to be held per baronium, a large standard feudal contract of tenure, common to all his barons. Such barons were not necessarily always from the greater Norman nobles, but were selected often on account of their personal abilities and usefulness. Thus, for instance, Turstan Fitzrolf, the relatively humble and obscure knight who had stepped in at the last minute to accept the position of Duke William's standard bearer at the Battle of Hastings, was granted a barony, which comprised well over 20 manors.
That's it. That's it. Okay. So we see English feudal barony started with William the Conqueror. So prior to William the Conqueror invading England and established his feudal barons, there were already barons in England called English barons. Okay. Very, very important to understand the difference between both barons, because barons are vassals that represents knights. Okay. They represent knighthood. Some were knights of lower standards, some were knights of higher standards. In that nature, you think about the Crusade Wars, okay? The First Crusade, the Second Crusade, the Third Crusade, all the way up to the Ninth. The Castilian Civil War, the Albicelestian Crusade, the 100-Year War. All this goes inside together, okay? It's like a picture with a picture and it's cut up and do everywhere, and we got to put the picture back together again to get back together again. So that's what we're doing. So we're talking about English barony versus feudal barony in regards to who are the true landowners, okay, of the estates and land, as well as the real estate that sits on the estates and land, and as well as the rights that are concerned about with the estates and land, meaning subsurface rights, air rights, water rights, etc. Whether it be on this part of the land or that part of the land. Okay, it all belongs to us because it's an inheritance from our forefathers who were sitting at the tenure of king. Okay, very important. So let's go back to Lords in the Manor and read a little bit more about that before we move forward. Going step by step.
Lord of the Manor is a title that in Anglo...
Countess, 1 second.
Oh, Normandy.
All right, we go here now. We're gonna go to Baron. Look up Baron now. Just look the word to find the word Baron. All right, touch on that real quick. We do your right here, Countess Smith.
Okay. Baron is a rank of nobility or title of honor, often hereditary, in various European countries, either current or historical. The female equivalent is baroness. Typically, the title denotes an aristocrat who ranks higher than a lord or knight, but lower than a viscount or count. Often, barons hold their fief or fight their lands and income directly from the monarch.
Read that again.
Barons
read that last paragraph.
Often barons hold their fief, their lands and income directly from the monarch.
Not right there. So all barons, whether you want to call them landlords, manage lords, tenant-in-chief, hold their fief. That means a tenure or a land tenure. That's a charter. Okay? So if you hold a charter from a king, then that should be called folkland because it was conveyed to you. That's called Library of Caesar. Okay? The Twig and Turf ceremony by Asselton, the great grandson of Alfred the Great. Very important. We understand how land is supposed to be conveyed. All right. So it says that Um, barons are knights, all right, of higher and lower noble, okay, and they are considered vassals of the king. They hold their fief directly from the king, i.e., the monarch, who sits in the position as holder of the crown in regards to crown land because the king personifies the crown. With that being said, let's go to the origin of where this problem came in. First Baron War. Since we know they mean landlords, either feudal landlords or English landlords. And that's we can truly say that, right? Either an English landlord or a feudal landlord. Okay? And if we look, ain't no English people out there but us. So we the only English people here in North America, and we know that we're the true landlords, and everybody else must not be. Okay, because we're reading the history right here, going all the way back to the first Baron Wars, the war between what? The landlords. This is the war between the ones who owns the lands. Let's get it. This is part of the first 100-year war, all leading to the Castilian War involving our ancestors that were French and Spanish, as well as the Albicelestian Crusade, going all the way back to the Spanish conquest. Okay, we were married into the French and Spanish house because we were all of the peerages of England. Okay, that had French and English pedigree. Very, very, very important to understand that, because if you don't understand that, then guess what? You're not family. Okay? The Kingdom of England. Belligerent parties, the Kingdom of England and the Army of God and the Holy Church and the Kingdom of France. This goes into what we call the Capetine dynasty. The Capetine dynasty were a dynasty that was warring with the Plantagenet dynasty, and Plantagenet dynasty was started by Godfrey V Count of Anjou, son of Fulk, ruler of Jerusalem. So if Godfrey V Count of Anjou was ruler of Jerusalem, well, we can pretty much note that the belligerents on the right side, Army of God and the Holy Church, is not the Kingdom of England, and they are not the rulers of Jerusalem. Okay? We can clearly make that distinction. And guess who's supporting the Army of God and Holy Church and the Kingdom of France? The Kingdom of Scotland. They're supporting the so-called Vicar of Christ because the Army of God and the Holy Church is the Roman Catholic Church, brothers and sisters. We must understand that. Commanders-in-Chief. King John and Louis VIII. If I'm not mistaken. I think it's Louis VIII. Louis VIII, okay? Louis VIII was responsible for holding not just the Shroud of Turin, not just the bones of John the Baptist, not just the skull of Mary Magdalene. Okay, these possessions or artifacts or relics are in the possessions of our ancestors. So these are the so-called saints that walk this earth, brothers and sisters, and we are related to them. Okay? Because we're going through the conflicts that they had with the lords of the land and those who were not lords of the land. They invaded the land where the lords were living. And guess where that was, brothers and sisters? Right here, North America. Let's look at it. Let's get into the origin of the conflict, brothers and sisters. Right here. Read it for me, Countess.
The First Barons' War, 1215 to 1217, was a civil war in the Kingdom of England, in which a group of rebellious major landowners, commonly referred to as barons, led by Robert Fitzwalter, waged war against King John of England. The conflict resulted from King John's disastrous wars against King Philip II of France, which led to the collapse of the Angevin Empire and John's subsequent refusal to accept and abide by Magna Carta, which John had sealed on June 15, 1215.
Stop right there. Okay, let's go down a little further. Let's go to background. Read background.
King John in 1215 was forced to put his seal to the Articles of the Barony, a group of powerful barons who were no longer willing to tolerate John's failed leadership and despotic rule. The king's great seal was attached upon it on June 15th of 1215. In exchange, the barons renewed their fealty to King John on the 19th of July, 1215. A formal document to record the agreement was drafted by the Royal Chancery on the 15th of July. This was the original Magna Carta. The law of the land is one of the great watchwords of Magna Carta by standing in opposition to the king's mere will.
That's called defamation per se, brothers and sisters. Defamation per se. Slander and rebellious against your king. If you ain't got a king, then it's your president. Either or, it's still considered defamation per se. We're going to talk about it. We're going to read this next paragraph.
Magna Carta held clauses that theoretically noticeably reduced the authority of the king, such as Clause 61, the Security Clause, which allowed a group of 25 barons to override the king at any time by means of force, a medieval legal process known as distraint that was normal in feudal relationships, albeit had never been applicated towards a king.
Stop.
After numerous
Read that first, read it from that Magna Carta to that point again.
Magna Carta held clauses that theoretically noticeably reduced the authority of the king, such as Clause 61, the Security Clause, which allowed a group of 25 barons to override the king at any time by means of force, a medieval legal process known as distraint that was normal in feudal relationships, albeit never had been applicated towards a king.
Continue.
After numerous months of half-hearted attempts to reach a settlement in the summer of 1215, open conflict was unleashed among the rebel barons alliance and the loyalist factions.
Now, very, very, very important, because what you're seeing happen to today in the streets all over the world is a result of distraint. All right? Those rogue feudal barons, and when we say feudal barons, those are ones who are called your landlords, okay? And those are ones who took the property from the ancestors, such as John, and then started taking the land for themselves through what we call subfeudation, and then creating new tenants. That's called subleasing. You heard the term subleasing. That's what you're doing. When you are a tenant, you're subleasing an apartment, okay? Very important to understand these terms. This is a result of what we call distraint, which we're forbidding as a result of the Magna Carta, because we're going to see that Edward I passed the distraint law. He passed a law going all the way back to John, his great-great-great-grandfather, or great-great-grandfather, one of the two. Very important to understand. So as a result of distraint, the 61 barons was able to take by force the property that belongs to the Angevin cadet branch of the Plantagenet crown. Very important, because we're all talking about what's going on today, because we know that barons are landlords, okay? Barons are landlords, whether you talk about them in that time era or whether you talk about them today. They're still the same, okay? Let's look at the word distraint. What does this word mean? Very important. Distraint. This was passed by the Statutes of Marlingborough, the law governing distraints. Now, what does this, we read in Wikipedia, but there's a law passed by our ancestors governing distraint. So what does distraint mean? Because we're dealing with the Baron War of feudal barons and English barons warring over the land, okay? And our ancestors, the true owners of the land, passed the law of distraint or deceit. I think that's what it's called. Let's look at it. Or distress, okay. Distraint or distress. Read that form, Countess.
Distraint or distress is the seizure of someone's property in order to obtain payment of rent or other money owed, especially in common law countries.
Stop. Hold on. That's crazy. So John passed a law saying that there was no distraints or distresses on any property belonging to the English barons. Okay? The reason why the Magna Carta Clause 61 was created so that they could overthrow by force the power and authority of the crown governing crown land, because the king personified the crown. So the king who personified the crown for the kingdom of England passed laws called the laws of distraint and distress for someone who was seizing property and then charging rent for it. All right, especially in common law countries. Think about that, y'all. So if these barons pass laws in common law countries to pass laws to pass for rent, that's called feudal law, brothers and sisters. That's feudal laws. You do that today. So you are subject to the laws of distraint. That's a violation of your ancestors' laws. How I know it? Let's read it. Let's read the actual law itself now. It's called the Statutes of Marlborough. Let's look at it. Passed by who? Henry III. Henry III was the son of John. John, son of Godfrey, son of Godfrey, son of Folk, the fifth kind of man Jew. Family. That's why I know. That's how we know this. So let's look at the statutes of Marlborough, which is the statute concerning distress or distraint. Read that first paragraph for him.
The Statute of Marlborough is a set of laws passed by the Parliament of England during the reign of Henry III in 1267. The laws comprised 29 chapters, of which 4 are still in force. Those 4 chapters constitute the oldest piece of statute law in the United Kingdom still in force as of 2025.
Stop right there. Let's go a little further. Let's go to background. All right, read the nomenclature. Read that real quick.
The statute is so named as it was passed at Marlborough in Wiltshire, where a parliament was being held. The preamble dates it as the 250th year of the reign of King Henry, son of King John, in the Utas of St. Martin, which would give a date of 18th of November, 1267. Utas is an archaic term to denote the 8th day in inclusive counting. So 7th day in normal English usage after an event, in this case, the feast day of St. Martin.
Okay, let's go here. The full title act passed that day was, we're going to read it in English.
All right. Okay.
Let's go ahead. Preamble. Start a preamble right here. No, not right there. Not right there. Let me find it. Right here. There you go. Distress Act 1267. Read this.
Chapters 1, 4, and 15, which seeks to govern the recovery of damages or distresses and make it illegal to obtain such distresses outside the legal system, are collectively referred to as the Distress Act of 1267.
Okay, so the Distress Act or the Distraint Act was also called the Statute of Marlborough, was passed by Henry III, the father of who? Edward I of the York and the Lancaster branch. They were warned as a result of what we call the 100-Year War and the War of the Roses. All right, as a result of marriage conflict. All right, resulting of who would inherit the throne of England. It's what it's all about. So let's read directly from the actual legislation concerning the Distress Act or the Distraint Act that was used for those for those rogue barons, i.e., landlords, to steal the land belonging to the true landlord, which was the descendants of the Plantagenet descendants, which we are today. Okay, did that make sense, Countess Middleton?
Yes,
Do you want to say a
definitely.
couple of words before we move forward?
Well, this is really clarifying the state of affairs. And, you know, again, another area is just finding a rental, a home property is so stressful and distressful for people now because of greed and people's misunderstanding of the whole where land really belongs to.
Yes.
And keeping us under feudal situations and conditions from what I see.
Exactly. Remember, they say, "He who writes your book sets your timeline. Time never was when we were not. If the time began, if the time began, if the time never was when man was not. If the life, the time began, I keep saying, I always rush, I talk too fast. Time never was when man was not. If the life be, no, that's not what it is. It said, he who writes your books sets your timeline. Time never was when man was not. If the life of time began, time will come when man would be no more. So if we let them write the time of our existence, that meant that we had a beginning and an end. And that would mean that they are our creators because they know our history and we don't. So we have to go back before his story, and his story is really our story, which remains a mystery to us until this present day. So this is why we understanding that we are under these constraints or under these distresses because we don't know our ancestors' laws, okay, which are here to preserve us in this present day. How we know it? Let's read the Distress Act from the actual legislative enactment by Henry III. Let's read it.
In the year of grace, 1267, the 250th year of the reign of King Henry, son of John, in the Utus of St. Martin, the said King of our Lord, providing for the better estate of his realm of England, and for the more speedy ministration of justice, also belongeth to the office of a king. The more discreet men of the realm being, let me just give this, I'm sorry, being called together as well of the higher as of the lower estate, it was provided, agreed, and ordained that whereas the realm of England of late had been disquieted with manifold troubles and dissensions, for reformation whereof statutes and laws be right necessary, whereby the peace and tranquility of the people must be observed, wherein the king, intending to devise convenient remedy, have made these acts, ordinances, and statutes underwritten, which he willeth to be observed forever firmly and inviolably of all his subjects, as well high as low.
Continue.
In what places distresses shall not be taken. It shall be lawful for no man from henceforth, for any manner of cause, to take distresses out of his fee, nor in the king's highway, nor in the common street, but only to the king or his officers, having special authority to do the same.
Now, do you understand what it's saying? That meant that we are not to be taxed whatsoever on the highways, on the byways, in our homes, etc. We are to be secure in all papers and effects. Very important to understand that. Why? Because I'm about to go ahead with it. So we just looked at the word distraint. Let's go here. Very important. What is defamation per se? Let's look at this term. We just heard Trump say that they like kings. He said that there's only one king that we really worship, our Lord Savior, the King of Kings. That's what he said. Okay? So if you're talking against the king, the Lord and Savior, that's called defamation per se. Would you agree, Countess Middleton?
Yes.
Okay, because he
Very,
didn't say he was king.
right.
He's telling you that the only king he know of is the Lord Savior. And you right out there saying that we don't want no king, or we don't want no king. You're actually saying that you don't want Jesus Christ to come.
Mm, that's
Look
right.
at that. He's telling you, as I shown you, that he likes kings. It showed you in the cartoon that you chose a president that wasn't a king to suit your wishes. Okay, so that meant that you didn't choose Jesus or any Jesus officers. That's what you're saying.
Mm,
You didn't choose Jesus or his officers. You didn't choose anybody who represented God. Because your president just said that he followed God and he followed King and he followed Jesus. That's what he said. He ain't saying he's him, but he's a messenger. Okay? And what y'all doing is an act of defamation per se. How many of you know what that is? If you don't know what it is, well, you better read it. Let's see. Let's read it for him. Read that for him. Could you see it?
yes.
Okay.
The tort of defamation or defamation of character occurs with false statements, either spoken, such as slander, or written, libel. False statement of fact injures a person's reputation. The First Amendment does not protect these statements.
Read that again. Remember, that's a separation of church and state. Okay? So if you're part of the state, the First Amendment ain't got nothing to do with you. It has something to do with you if you want to believe in some spook stuff or whatever it is that you believe in. You can even believe in Jesus Christ if you want to. But it has nothing to do with the First Amendment. All right? Donald Trump is saying that the guy he believes in is based upon the First Amendment. Okay? And apparently that must be a king because he referenced King, Jesus, and God in the same breath. All right. So we're reading the defamation of that God, that Jesus in the flesh, apparently because he's supposed to be coming back in regards to being the King of Kings, which Donald Trump said he recognized, had always recognized. But so that meant that he ain't the same president that you guys elected. That's a result of why you're saying that we don't want no king. You said it in your cartoon all the way back at the time of the founding fathers. You got a cartoon with the founding fathers saying you elected a president that did not uphold the wishes of a king. But now your president has turned on you. Why? Because he knows the king is back. He ain't talking about some spook king. He knows he's talking about a real king coming back. He ain't telling you, but he knows the king is back. Let's read it. Why? Read that definition. Continue on.
The tort of defamation or defamation of character occurs with false statements, either spoken, such as slander, or written, such as libel. False statement of fact injures a person's reputation. The First Amendment does not protect these statements. Some types of false statements are so damaging that they are defamatory on their face, defamation per se. Defamation per se differs from defamation per quote, where the court must look at the statement's context, because defamation law divides offenses into libel and slander. The law recognizes instances of slander per se and libel per se.
Okay, go down
The
to false.
law,
One second. Go down here.
right.
False
Okay.
statements that constitute defamation per se.
Right. There are four main ways to classify false statements that the law presumes to be harmful to a person's reputation. Generally, if the statement does not fit into one of the four categories, the plaintiff must prove their actual damage. Here are four categories of defamation per se. 1, saying that someone committed a crime or immoral conduct conduct, which may also involve a false police report. 2, saying that someone had a contagious, infectious, or loathsome disease. 3, saying someone engaged in sexual misconduct or was unchaste. 4, saying something harmful about someone's business, trade, or profession.
That's it. Okay, so 2 and 3 don't apply in this case. All right, because those deals with matters concerning physical contact, etc. First one and the last one are very important, especially when you're dealing with your king, King Clifford Jefferson. Why is this important? I was arrested, which I go to court tomorrow, for 2 things. A second-degree offense for claiming to purport to have an ID in my possession that purports to be a driver license or a birth certificate, which is a second degree offense, which means I could be facing 5 or 10 years. The second charge was trying to record an instrument with the county recorder, knowing it was fraudulent. Okay. Now, I have a matter in the appellate court right now in regards to the allodial land that belongs to the Anglo-Saxons. Okay, right before the Chancery Court. But the Chancery reason why it's at the appellate court is a result of the discrimination and the biasness of not just the Chancery Court, but the Law Division as a result of what happened in the criminal court of being arrested when I was at the county clerk office trying to file an instrument called a deed for a parcel of an estate on the allodial land in New Jersey. Now, New Jersey, the whole land is allodial. I was going to file a parcel estate in the state of New Jersey in regards to the allodial right that I have. My ID says it in the left-hand corner, allodial substantive birthright. On the left-hand corner, it says allodial substantive birthright. On the left-hand side, it says descent, Anglo-Saxon. Okay, now this is the instrument that they said was a second-degree offense and that I could face 5 to 10 years. I filed an affirmative defense for motion to dismiss for lack of probable cause, which if it was dismissed, it would be a malicious prosecution because of the defamation per se. As a result of 1, saying that someone committed a crime or immoral conduct, which may be also involve a false police report, meaning filing not having probable cause. And 4, saying something harmful about someone's business, trade, or profession. My profession is what? The King of England. Right? That's my profession. That's my trade. That's my business, etc. I am the King of England. When I was arrested, as one says, the county recorder of the county clerk filed a complaint with the state in regards to some claim that I committed an unlawful act by claiming that I was going to file a fraudulent deed, which presumes that they have probable cause. All right. Now, I filed the motion to dismiss for a lack of jurisdiction as well as a lack of probable cause. Why? Because 1, they actually, when I filed a motion to dismiss, I shut the court down, shut it down. I even told the public defenders to sit down. I got this. They moved the whole entire case from the original courtroom to another courtroom where it was just me. Added the whole 15 minutes. The prosecutor that was there, they took 2 minutes. The rest of the conversation was just me. And I shut the courtroom down. After I argued my point based upon why ground for motion to dismiss should be warranted, the judge said, "You really know your history." I told the judge, "I'm the best." Now, the judge didn't want to dismiss the charge because they know if they would have dismissed it, it would have been a malicious prosecution. So they said they offered me a plea bargain, which was disorderly conduct. Now, the recording the fraudulent deed was a disorderly conduct charge, and the ID I had in my possession, such as the members' ID card dealing with us being part of the 13th Church of England, that was a second-degree offense. Now, the plea bargain was that they would drop the second-degree offense, i.e. the ID that I had, and charge me with trying to record a fraudulent instrument. Why did they do this? This was a very bad mistake because it was defamation per se. Let me explain this why. Okay, so now the plea is that if I agree to recording a fraudulent deed, they would drop the second degree offense, which is 5 to 10 years, which is having a fraudulent identification card, i.e. a membership card to our church. Now, if they drop that charge of the drivers of the instrument, i.e. the driver license, my ID being fraudulent, that meant that under what they call double jeopardy, I cannot be charged again with that ID being fraudulent. That meant that, in fact, the ID was in fact valid. So if you drop that charge, that would mean that the ID, my member's ID to us being Anglo-Saxon, having a allodial birthright as well as being Anglo-Saxon, that meant that you could not possibly charge me with an invalid instrument being trying to file with the county recorder because the instrument said in it transferring the land in the allodial transfer. It says the instrument said an allodial transfer. So if you charge me or make me plead to trying to record an instrument that was fraudulent, it's invalid because the transfer of the instrument was based upon transferring the allodial land. And on my ID, which you dropped that charge, says allodial birthright. So if the allodial birthright is valid, then the transfer of the allodial land is valid as well. Whether you're talking about the whole allodial land or a parcel estate, the identification of the ID card attached to the certificate of incorporation justify my actions. Okay? 2, if you do charge me with that instrument, that's fraudulent as well. Why? Because it's not the job of a criminal court to validate if an instrument is fraudulent. That is the job for the chancery court. So it had to be dismissed as well. That's another mistake that they made. So as a result of dropping the ID card, which is the membership ID to our church, and saying it was valid, on that ID card it says allodial extension birthright, which justified the actions with recording the actual instrument called AD for the parcel of a state, not just the allodial land, but a parcel of a state on the allodial land. And you want me to plead to that, but how can I plead to an instrument when the instrument is not valid? You never even proved that the instrument was valid. I told you in the motion to dismiss the criminal complaint that this court cannot prove that the instrument was valid and was fraudulent. You have to forward this matter to the chancery court to prove that the instrument is invalid or fraudulent. Once that court proves that it's fraudulent or invalid, then you can take criminal actions. The judge looked at the prosecutor like, you hear this man talking? So now tomorrow I'll go to court to have that matter dismissed by taking that plea bargain, but I still have a right to appeal that decision in 45 days. So I'm going to appeal it by way of a motion to consolidate it with the actual appeal that's before the appellate court right now in regards to the allodial land. So what this is going to do is have a snowball effect, because I have proven that as a result of who I am, you have committed defamation of character as a result of my business of transferring the land back to the true possessors. And as a result of that, what? You lock me up. That's called defamation per se, based upon part 1 and part 4. How I know it? Let's read the 4. So I had asked AI what he thought about it, and this is what AI said. Let's see. Thank you, Brother McGarrett. That might be hard for some people to understand, but you might have to watch this lesson a couple of times. Let's read this. Let's see what defamation per se means for a king, if you do it to a king, because apparently the video we watched when we open up shows that there's defamation being done in the name of a king, because they're saying no king. Trump never said he was king. So if Trump's telling you that he honors king and that there's the only king that he know of is Lord, Savior, Christ, Jesus Christ, Lord of Lords and King of Kings, when he do come back, guess what? You're gonna be violated for defamation of per se. Why? Because read what it said. Read it for me, Countess.
Historically, statements considered harmful to a king could range from mild criticism to direct incitement to rebellion.
Stop.
Here are some.
Stop right now. Now, when she read this, think about what's going on in the streets in 2025 over no king. Now, I am a king because of our incorporation. Corporate powers derive their powers from a corporate grant, from a sovereign grant. We're going to explain that in a second, just in case none of you know that. But when we read this in the eyes of defamation per se, when you're acting in the manner that you're doing right now, it causes distraint and dis-ease. That's a violation of our ancestors' laws who were kings. So when I am restored to my tenure, you are going to be in a world of trouble. That's why I'm telling you, my brothers and sisters who are of Anglo-Saxon descent, do not get involved. Continue to read.
Here are some examples of statements that might be considered harmful. 1. Directly challenging the king's authority or legitimacy. The king is not chosen by God and should not rule over us. This questions the divine right of kings, a common justification for their rule.
Stop.
We should
Stop right there. Now, didn't King James claim to be king under what? Divine right of kings?
Yes.
Because God makes kings. So Donald Trump understood that as well. God makes kings. That's why he honored kings. Your presidents before him didn't honor that. So they're violating what? God's laws. Because God makes kings. So for you saying that no king and he don't have no divine right, that's called defamation per se. Because it causes rebellion and distraint. The statute of Marlinborough said you couldn't do that, and the Distraint Act of 1267 said you could not do that. They are still applicable today because there's case law out there in 1991 validating it. How we know? I'm going to show you. Continue.
We should overthrow the king and establish a republic. This calls for a revolutionary overthrow of the monarchical system.
Isn't that what they did? They give you
Yes.
examples of defamation of a king. And this is exactly what you did in 1776, and this is exactly what you're doing right now. Without you even realize what you're doing. Continue.
The king is a tyrant and is unfit to rule. This could justify rebellion as seen in the American Revolution.
That's distraint or disease. That's what you brothers and sisters are doing now, and you did it at the time of the revolution. History repeats itself. What? On the anniversary day of the Magna Carta. There are no happenings, brothers and sisters. Let's read the next one.
You have to move. Okay. Number 2, accusing the king of wrongdoing or incompetence. The king is wasting the kingdom's resources for personal gain. This undermines the king's image as a responsible ruler. The king is weak and unable to protect his people. This could erode public trust and support for the monarchy. The king is corrupt and favors his cronies over the people. This could spark resentment and potentially lead to unrest. Number 3, promoting or inciting rebellion or dissent.
Yeah.
Rise up against the king and take back our rights. This directly encourages rebellion. We should not pay the king's taxes. This challenges the king's authority to levy taxes and could lead to civil disobedience.
Stop. This is going on right now. Y'all pay taxes. Y'all upset with the government and the leader of the government that was put in place under the crown's authority, okay? Under a feudal government, which was left here by the Scottish British monarchs, okay? That was the government that was here prior to those people coming over here and setting up shop as feudal barons or feudal landlords, and they're still here today because you don't know your rights. Okay, so look at some other examples before we move forward.
The king is a traitor and has betrayed the people. This could incite people to rebel against the king for treason. 4, making insulting or derogatory remarks about the king or his family.
Boy, y'all better listen. Y'all better listen. We family right here. We all family here at the church. Okay, so you say anything about me or my family, you're in a world of trouble. And you're already doing it right now. No king. If you ain't got the king, you don't want no king, that means you don't want his family. We got a problem. Continue.
The king is an idiot, doesn't know what he's doing. This type of statement, depending on the context and laws in place, could constitute least majesty, or let's say majesty. The king is a lecher and a coward. Such statements damage the king's reputation and could make him appear unfit to rule.
That's it. Okay, so all these statements that you make on behalf of a king, which you don't even have, can be detrimental if there is a king coming into an existence that which is because you don't know he exists. Okay, so everything that you're doing right now is going to mess around to affect you and physically as a result of your actions. Why? Because you are making derogatory, defamatory, libellous, slanderous arguments against a king that you don't even have. That you never even had a king. So for you to make those statements against a king is still defamation because some people do have kings. Some nations do have kings. This is the reason why you got away from that because you didn't want a king. We already proved that point. Let's continue. All right.
Important notes.
1 second. No, we can leave that alone. We're gonna go back to the.
Okay.
Let me just close out of this one real quick. Share. What's up here? All right, now we're going here. Let's see. First Grand War. All right, let's look at this one now. We look up the strength law, and that was the statutes of Marlingborough. Now we're going to look at waste law, okay? Very important. What is waste law? Let's look at that real quick. Let me just close my screen up. All right, here we go. Waste law. Now we already see, based upon us going back into history and looking at the Magna Carta and the purpose intent of why the Magna Carta was signed, which was a result of some feudal barons who claimed to have a right to land ownership, and as a result of that, they have created new tenants through what they call subleasing. Okay, this is called subinfeudation, which is a violation of Queen Praetorius, which forbidden laws, which were laws forbidden the selling of land or the using of land contrary to how it was conveyed to you. When you do that, it's called waste. Okay, waste law. So let's review what waste law is for you. Waste law.
Waste. Okay. Waste is a term used in property law to describe a cause of action that can be brought in court to address a change in condition of real property brought about by a current tenant that damages or destroys the value of that property. A lawsuit for waste can be brought against a life tenant or lessee of a leasehold estate, either by a current landlord or by the owner of a vested future interest.
Read that again. Okay. A lawsuit for waste. Start there.
A lawsuit for waste can be brought against a life tenant or lessee of a leasehold estate, either by a current landlord or by the owner of a vested future interest.
Read the next, continue.
The holder of an executory interest, however, has no standing to enforce an action for waste, since his future interest is not vested. There are several different kinds of waste under the law.
Okay, so what is it saying? That waste law is when somebody that are get when it's called substitution. Let me just make sure I get my picture up there 1 second. It's called substitution. Substitution is when you convey it based upon how it was conveyed to you, and you still hold up to the same encumbrances. Okay, this is how conveyance is done. When you take something and carve out new tickets for themselves, this is a violation of law because now you have uses other than the purpose and intent, which is called waste law, because now the property value has changed for the property. Just say if you had a property, i.e. real estate, and you got a tenant and the tenant damaged the property. All right. Now, the so-called landlord of the property, i.e. are corporations or claim to be landowners. So when a tenant who's in possession of the property by way of it assumed to be conveyed to him, assumed to be lawfully, when that tenant damaged that property, they have what they call title insurance to be able to provide some type of a remedy in regards to the property being damaged. This is what we call waste law for us as Englishmen and women. When you damage the property value in regards to how you acquired it from the original landlord, then you are responsible as well as that landlord is responsible for the damage that's done to the land that actually belongs to the original owner or the true owner of the land, i.e. called the landlord. Because it said, and the executory interest cannot have any standing in law. Why? Because you're not an heir. All right. As heirs, we have a future interest. Why? Because there's only three types of ownership here in North America. What is called fee simple, which is absolute. All right. The highest form of ownership. The feasible, not indefeasible, but the feasible, meaning that it's not a clear title. And what you call life estate, meaning that you have that ownership or you come into that possession for the life of the tenure. Once you die, it goes back to the original owner. Very important to understand that. So it clearly says, and I repeat what Countess stated. He said that waste is a term used in property law to describe a cause and action that can be brought in a court to address and a change in condition of real property brought about by the current tenant that damaged or destroys the value of that property. This is called the Statutes of Gloucester, okay? Passed by our ancestors. So we actually got the Statute of Marlborough, which deals with distress or disease, which was a result of the signing of the Magna Carta by those 61 roll barons. Which is it? What, the 61 or 21? Whichever number amount there was, because I'm pretty sure there are a lot more feudal barons here today, in the thousands, okay? Nonetheless, how you came into possession of your tenure was unlawful because it was through the process of substitution, and that means alienating land that does not belong to you. That's a violation of law. And then when you take that property that you use by way of alienation, and then you do whatever you want to do with it other than how you received it, that's called waste. Okay? And the true owner or the true heirs have the right to bring a claim based upon reversion and remandment of their lawful estate, and as well as be paid back triple damages. Did you hear me? Triple damages, as well as have that property taken from you as a result of the waste or the damages that's been done to it. And the people we're talking to is you landlords, okay? The ones who don't own the land by way of it being a part of an inheritance, okay? Very important. How we know it? Let's look at it. Statute of Gloucester. Passed by Edward I. Read it for him, Countess Middleton.
The Statute of Gloucester is a piece of legislation enacted in the Parliament of England during the reign of Edward I. The statute, proclaimed at Gloucester in August 1278, was crucial to the development of English law. Statute of Gloucester and the ensuing legal hearings were a means by which Edward I tried to recover regal authority that had been alienated during the reign of his father, King Henry III, 1207 to 1272, who had been made a virtual tool of the baronial party led by Simon de Montfort.
Stop.
Edward
Okay. So we're talking about the first, the second Baron Wars. We went from the first to the second Baron War. We started with the first one with Henry III, and now we're in the second with Edward I. All right, all these statutes, the statute of Marlborough governing the strength of disease, the statute of Gloucester governing waste, when you take or misuse the property and deplete the property's value, when you're talking about the land, the air, the water, etc., you are committing waste. All right? These are preserved in New Jersey statutes, brothers and sisters. They are called reception statutes, statutes that were incorporated by what? Your founding fathers and their ignorance, okay? In their own ignorance, they have recorded, incorporated, or instilled these laws for our protection, all right? Going all the way back to the feudal barons or the feudal landlords, going all the way back to William the Conqueror, who invaded England and brought in the system that still exists today, and it has to stop. It has to stop. Let's continue. Where are we at? All right, this is called the Statute of Gloucester. It has to do with waste, but I'm not going to go through this. We're going to go through a case law and justify the statutes that we just read. We talked about the statutes of Marlborough, which deals with the strength and disease, which caused the first and the second Baron War. Now we're dealing with the statute of Gloucester that's deal with waste, and as well as the statutes of Westminster of 1275 and the statute of Westminster of 1270 what was it? Statute of Westminster of 1285. So you got the Statute of Westminster of 1275, the Statute of Westminster of 1285, the Statute of Gloucester of 1278, and the Statute of Marlborough, whatever year that was. And I forgot what year that was. All right. Then we have the Queen Imperatoris, which we already read. We read that one, law against alienation of property through substitution. That was passed in 1280, if I'm not mistaken. I don't want to go back to it because we already touched on that. I'm trying to go to the case law now to justify the Statute of Gloucester, the Statute of Marlborough, the Act of Westminster of 1275 and 1285. We're going to see all these four acts of legislative enactment of our ancestors, our peers, our English barons, put in place to preserve our history. And they're talking about this in 1991 by Chief Justice Mark A. Sullivan. Okay, Chief Justice Mark A. Sullivan in Briggs versus Henley. All right, we're going to go to that case right now. Talking about waste law. Briggs versus Henley. You all right, Countess Middleton?
Yes.
Okay. Let me find it first. Right here at the top, at the opening. This case is only 4 pages. Chief Justice Mark A. Sullivan was a appellate court judge, a Supreme Court judge, a district court judge, as well as he did some other things. All right, he was responsible for the judicature of the associate justice of the district courts, in Hudson County, whatever. You can look them up on your own. But it's Chief Justice Mark A. Sullivan. Look him up, from New Jersey. This is Birch versus Hangley. Once again, Birch versus Hangley. Let me show you it. And you can start from the beginning, Countess Middleton.
Birch versus Hanley. Kevin Birch, plaintiff pro se. This application concerns the continued viability of New Jersey or NJSA 2A65-3 in awarding landlords triple damages for waste committed by tenants.
Y'all hear that?
The statute.
Read that first part again. We're talking about a New Jersey revised statutes or New Jersey statute annotated 2A65-3 in regards to what we just read about waste. About waste. Now, we're going to read the statute first before we go into this case law. Okay? We're going to read the statutes first, and then we're going to go into the case law because we might be like, oh, that's just case law. We don't believe that. They just talking junk. Okay, let's see what they're saying in the actual statute and then refer to the case law. Because whether you believe the case law, you can't say the statute is wrong. Okay? We're going to go into New Jersey Statute 2A65-3 in regards to those who committed waste, and you're not going to see nothing in there about a landlord. Nothing whatsoever about a landlord. But what you will see is an heir that can file a complaint in New Jersey for triple damages when waste has been committed. What heir? The Anglo-Saxons, brothers and sisters. Not no lord, landlord, none of that. Okay? Because it does not belong to them. They're the ones who committed the waste on the land. All right? Let's prove it. First of all, let's look at the word landlord as it's defined in New Jersey Revised Statute 46:8-27. Landlord. As defined. So we don't want to use words loosely. New Jersey Revised Statute Title 46, governing property, brothers and sisters. It ain't in any other statute, but with the statute it needs to be. Governing property, landlord, and projects defined. When we're dealing with a project, it's usually a building project. Okay? Let's get it. Read that first paragraph.
1. The term landlord, as used in this act, shall mean the person or persons who owned or purport to own or exercise control of any building or project in which there is rented or offered for rent housing space for living or dwelling purposes under either a written or oral lease, provided that this definition shall not include owner-occupied 2-unit premises. This definition shall include, but not be limited to, any multiple dwelling subject to the hotel and multiple dwelling law.
Okay. Read the next one. And stop right here.
Whenever the owner of an apartment in a horizontal property regime as defined in PL 1963.
You ain't got to read the public law. You ain't got to read that. Just read the word.
A unit owner of a unit in a condominium as defined, an owner of a unit in a fee simple community as defined.
That's fine. So that's fine. So all they're really saying is that a landlord, whether you're talking about whatever property you're talking about, horizontal properties, condominiums, units, apartment buildings, double units, or how many you got, they're still talking about, it all relates to the definition of the word or the term landlord. Okay? Right here in Title 46, Section 8-27, 46:8-27. They find the word landlord, and landlords denote to those who have a possession and fee simple. Fee simple versus entail. Once again, fee simple versus entail. And you notice they said who owns or who purports to own. You see that?
Right.
Who owns or purports to own. They didn't say who owned it because they know they're lying. Why would, if you own it, why would you put the word purport to own?
Right.
Why would the legislature put that in there? Because they know they don't own it. All right. How we know? Let's go to the one who really owned it, the king. It's still here in 2024. Ain't nothing changed. Read that for him.
The tenures of honors, manors, lands, tenements, or hereditaments, or of estates of inheritance at the common law, held either of the King of England or of any other person or body politic or corporate at any time before July 4th, 1776, and
Stop.
declared by
Stop right there. So it says the tenures. We know a tenure is a charter because we're talking about landowners, land tenures, and landlord. You can't be a landlord until you get a land tenure, and the only way you get a land tenure is from the landowner. Okay? And that original landowner will be the original landlord. All right? So you got the landlord who is the landowner. And then the landowner who is the landowner who is the landlord gives out a land tenure to another person who's supposed to be or acting like a landlord. Meaning he's a middle landlord. Okay? He ain't the lord paramount. He's just a landlord subject to a superior lord, which is called lord paramount. That, in fact, would be the king. And all the lands, manors, what was the first one? The tenures of honors and manors. They talking about what? Lords of the manors. They're talking about those landlords. So all the land that belongs to the landlords and the manors, they got them first. And it said the tenements, as well as those tenures that go or derive from hereditaments, meaning that heirs or estates of an inheritance at the common law held either. It didn't say landlord, did it, Countess Middleton?
no,
It didn't say the King of Scotland, did it?
nope,
It didn't say the King of Ireland, did it?
no,
It didn't say the Moorish king. It didn't say a king from the Bible. It said the King of England. Before what year? July 4th, 1776. So the king's government, body of politics, corporate was here before July 1776. Okay? And that meant that all 10 years before and after will remain in free and common soakers because that's how the fees were supposed to be paid back to the crown once you got your land tenure. Okay? It's called common soakage. Common soakage. Let's get to it. And we know that what we're reading here only reflects what we're about to read here. New Jersey Provincial Council, His Majesty's Council, called the Crown of England, right here in New Jersey. Let's look at it before we go on. Right here. Just go in the box. What that say, the authority of the crown.
mm. Wow.
Indefinite. So before the Treaty of Union of 1707, the crown, i.e. of England, was sitting right here in New Jersey. Before what? 1776. Let's read it for ourselves. It says His Majesty's Council for the Province of New Jersey was the upper house of New Jersey Legislative under the colonial rule until it was replaced by New Jersey Legislative Council on July 4th, 1776. It's right there in black and white and blue. Okay, very important we understand that. And his government was a provisional government that was fused together. Okay, the executive, legislative, and judicial. Well, William Franklin was the last royal governor before it was superseded by who? William Patterson. Why is this important? Because William Patterson incorporated the statutes of Gloucester, the statutes of Marlborough, as well as the Act of Westminster of 1275 and 1285. All these ancient enactments were incorporated by William Franklin, William Patterson, the successor of William Franklin. Let's make sure that's correct first before I go on. William Franklin, who was his successor? Let's see. It wasn't William Livingston come after William Patterson come after William Livingston, if I'm not mistaken. Let's see. He's somewhere here. 1 second. Let me find it. Let me go back on. I can do you one better. Just look up William Patterson for ourselves. Let me just look him up real quick. Bear with me. William. He was a judge. He was the Attorney General. Yes, Attorney General. Bear with me, brothers and sisters. Here we go. William Patterson. All right, here we go. You share it. All right, William Patterson. William Patterson succeeded Attorney General. All right, there you go. All right, so Governor was William Livingston, and Attorney William Livingston was Attorney General, and William Patterson was Attorney General. So we're looking right here. William Patterson, he was the governor, second governor, right? Succeeded Henry Livingston. All right, so let's go backwards. If he was the second governor, William Patterson, he was preceded by Thomas Johnson. Let's go back one. Thomas Johnson was succeeded by who? Associate Justice of Supreme Court. William Patterson. I just read William Patterson. All right. Read the first paragraph of William Patterson.
William Patterson was an American statesman, lawyer, jurist, and signer of the United States Constitution. He was an Associate Justice of the United States Supreme Court, the second governor of New Jersey, and a founding father of the United States.
Okay, so he was the second governor of New Jersey. Who was the first governor of New Jersey? William Livingston. Now let's look at the governor of New Jersey present day. That will be what's his name? Governor Murphy, Phil Murphy. Now let's see who Governor Murphy works for. Okay? Let's see who Governor Murphy works for in New Jersey. Before we go to the court case. You see this right here? Constituent instrument, New Jersey's Constitution of 1776, precursor, Governor of New Jersey, Great Britain. Why would they put that there? Why would they put that there? Governor Murphy is the governor of New Jersey of Great Britain. So he even knows its history. Very important we understand that, because from William Livingston, let's go right here. And then we're going to go back to the case law. First governor, so right here, William Governor was the first governor of New Jersey, and they said the second governor was who? William Patterson. Didn't they say that?
Yes.
First governor was William Franklin. Parcel. Yeah. William Livingston was the first governor, and the second governor was William Patterson. That's it. All right. He was preceded by William Franklin. All right, as the royal governor. So the royal governor was William Franklin, the son of an illegitimate son, Benjamin Franklin, and William Franklin told Benjamin Franklin and the rest of the founding fathers that you better not do what y'all trying to do. You better not do what you're trying to do. So we see that when William Franklin was locked up, guess who took over? William Livingston and William Patterson, the governor of New Jersey, but they should be under the authority of the crown. We see that. So let's look at the case law, Brick versus Haney. Going back to the case law. All right, here we go. All right. Oh, yeah, I know what I want to do. I want to look at the statutes before we go into this case law. We already read the one dealing with the landlord, and the landlord was a corporation because it said it was a juristic person. Two, it said they only had the right to fee simple estates, and fee simple estates are those through the practice of common recovery. So why this is important is that landlords cannot get treble damages, okay? Only heirs can get treble damages according to the history. But when you read this case law, they're going to associate the treble damages with landlords, all right? Listen close. When we read this case law, they're going to associate New Jersey Revised Statute or New Jersey Statute annotated 2865-3 all the way through 6. They're going to associate that in this case with landlord. But when you read the statute we're going to go to right now, you're not going to see the word landlord nowhere in there. So even the judges are lying because they know we don't know. They know we don't know that they ain't actually landlords. But because we don't know that, they're going to use this statute for landlords to collect treble damages when we don't pay their rent. Does that make sense, Councilman Middleton?
Yes. Although anything that helps to qualify that now just kind of helps me to validate it even more.
Well, let's validate it then, Councilman Middleton. She asked for it, let's get it. Let's validate it. New Jersey by Statute 2865-3. Let's see it for ourselves. Right here. Now, you ain't going to see nothing in the statute that you're going to see in that case law we're going to read after we read the statute. Okay? But everything you read in the statute that is in the case law all concerns statutes and acts from English Parliament. Why? When we read the case, you're going to see the laws governing waste going all the way back to the law passed by Henry III and Edward I in the case law, but they're going to refer to those people as landlords, but they wasn't landlords because the landlords that they're referencing to is feudal baron because there's no landlord in this statute right here. But you're going to see it in the case law. So when we read the case law and we read the statute, we're going to know that they're lying. Because we're going to go from 3 to 6, and you're not going to see landlord not one time, but you will see heir. Let's read it. You can read, Countess.
2A6 colon 65-3. Action for waste, treble damages. A civil action may be maintained in the Superior Court against the tenant, and upon a finding that waste has been committed, treble damages shall be assessed or granted, and the defendant shall lose the thing or place wasted.
Listen, y'all. Did it say any landlord? No. It just said tenant. A tenant can be sued in a court of law, a superior court, based upon treble damages when waste has been committed, and we already know what waste is. The changing of the value of property in the hands of somebody who's not the owner. Okay? Whether it's a superior lord or a tenant-in-chief or a lord in the manor or whoever he subleases it to. If they damage that property, and we're not talking about real estate, we're talking about estates in the land. And we see that happening right now because the land is in the uproar. Trees cut down, they're building new apartment buildings, etc. This is a violation of the statute right here. But you don't know it. Why? Because you read it in English, but you're not associating English history along with it. All right? When you do that, the picture comes clear. How we know it? Let's go to, we ain't going to read section 4, we're going to go to section 5. So we're going to go 2 sections up. That's, this is 4, and then we're going to go to 5. Read what this says.
2A:65-5, action for waste by air, treble damages. Any heir may maintain a civil action for the waste or destruction of his inheritance, whether
Read that
such
again.
waste.
Read that again, Countess Middleton. That's scary for me. That is very scary right there. It didn't say nothing about no landlord. It said an heir based upon the inheritance of a lost or a dead ancestor. That is mind-blowing to me when you understand it like we understand it. Read it.
Any heir may maintain a civil action for the waste or destruction of his inheritance, whether such waste occurred in the lifetime of his ancestor or thereafter. The judgment in such an action shall be for the recovery of the inheritance wasted or its money value if such recovery is impossible, and treble damages.
Now, don't that sound like the statutes of Gloucester and the statute of Marlborough?
Yes, it does.
Right there. Why? Because the statute of Westminster of 1275, the statute of Westminster of 1285, the Don'ts Conditional Bus, Queen Praetors, these were laws put in for us to get paid back. Didn't nobody say you're going to have to pay back in compound interest? That's what he said. Yes. But you can't do it without the king. Magistrate and subject. Let's go to the next section. Read that for him.
Okay. When any tenant, tenant's liability for waste committed or suffered by him and leasing or granting his estate to another. When any tenant for a term, including a life tenant, in property demised to or held by him, has or shall lease or grant his estate in the property to any person, and shall thereafter continue to occupy such property, or to take the profits thereof, and shall commit or suffer waste and destruction thereof. The owner, remainder man, or reversioner of such property may maintain a civil action against such tenant and recover from him the property wasted or its money value and treble damages, provided such tenant was liable for waste before he leased or granted his estate, but not otherwise.
Okay, so this goes right to back here to what we're just reading. Where is it at? Distraint. What is distraint?
Distraint or distress is the seizure of someone's property in order to obtain payment or rent of other money owed, especially in common law countries.
What more else needs to be said? What more else needs to be said? Let's go back to what? The First Baron War? Read this chapter right here.
Magna Carta held clauses that theoretically reduced. Magna Carta held clauses that.
When you read, go ahead and elaborate because I want to run to the bathroom.
Oh, okay.
You can go ahead and continue. Go ahead and read. Elaborate.
Okay. Magna Carta held clauses that theoretically noticeably reduced the authority of the king, such as Clause 61, the Security Clause, which allowed a group of 25 barons to override the king at any time by means of force. a medieval legal process known as distraint that was normal in feudal relationships, albeit had never been applicated towards a king. After numerous months of half-hearted attempts to reach a settlement in the summer of 1215, open conflict was unleashed among the rebel barons' alliance and loyalist factions.
Well said. Well said, Countess Middleton. You want to build on that, or you want to move forward?
We can move forward. That
Okay.
really clarifies.
Okay. All right. So let's go back here. We know that based upon the waste, as well as the strength or desist, an heir can bring a claim as a result of the descent as well as the waste on the land, and we can get treble damages. I didn't say that. Chief Justice Sullivan going to say it. Let's go back to the case. Briggs versus Haney. Okay. Still talking about the same statute, and it did not say not once landlord. Did you hear the word landlord, Countess Middleton?
No, I did not.
Now watch how it pop up all of a sudden. Continue to read.
This application concerns the continued viability of NJSA 2A:65-3 in awarding landlords treble damages for waste committed by tenants.
Did you hear that? Did you hear that? Why would they put that there when in the statute ain't nothing in there about a landlord?
Right.
Does that make sense?
No. And
if the statutes would, if you're saying landlords, then where's landlord in the statute? We read 65-3. It didn't say, it said you can bring charges against a tenant, but it didn't say who that person is can bring the charges. But the case is saying landlord, but the statute don't say landlord. But if you go two sections down, it says an heir. It is. You only see landlord in chapter 48, chapter New Jersey Revised Statute 46:8-27. You see him there. You don't see him landlord in 2A:65-3, -4, or -5, or -6. You see heir. All right. So you know when you read this case and you see the way landlord, they're lying. How we know? Because when John passed the Magna Carta, was forced to sign the Magna Carta, it was based upon the laws of distraint and dissent. This is the reason why Edward I passed the statutes of Marlingborough, the statutes of Gloucester, the statute of Westminster, etc. How we know? Let's read it. All right, go ahead.
A civil action may be maintained in the Superior Court against the tenant, and upon a finding that waste has been committed, treble damages shall be assessed or granted, and the defendant shall lose the thing or place wasted.
So you see, they quoted the statute as it says in entirety. They quote it verbatim. But then when the judges make their statement of reason, they automatically put the word landlord in there. But the landlord is not in the statute. So how would you make that assertion? Does that make sense?
Correct. So King, so that's a case of stolen identity.
Yes.
Which it says.
Yes. Okay. Defamation of the character of the true heirs. Right. Because we have an obligation based upon Article 1, Article 2, and Article 3 of our certificate of corporation to make sure that this property don't fall in the hands of the wrong person. We are obligated to do this. So continue to read.
Although the genesis of this statute dates back to England when the Statute of Marlbridge was enacted in 1267, there is very...
Statute of Marlingborough.
Oh, okay. They say Marlbridge. Interesting.
It's the one. It's actually Statute of Marlingborough. You know they don't know history, so they said the word wrong.
Right. Wow. Wow. There is very little recent case law on the subject.
I wonder why. I wonder why.
In 1950, the United States District Court for the District of Delaware ruled that the New Jersey courts did not apply that statute to common law actions and therefore declined to award treble damages to the owner of movie theaters that had been leased to defendant Warner Brothers, Fox versus Warner Brothers Pictures. The within action is a common law claim for rent and intentional damages by plaintiff landlord against his former tenant. Defendant is in default for failing to appear. At a proof hearing, plaintiff requested treble damages pursuant to the above statute, which he found in the, on the next page, in the Department of Community Affairs Truth in Renting pamphlets.
Stop. So it means he found this statue that mentions statue going all the way back to England in some damn pamphlet and tried to use it. You see that? See the competency of people who claim to know law and don't have a clue of what's going on. They don't even see this coming. Let's go to the meat of this argument. Let's go here. Right here.
Okay. Where do you want me to start? Where the court, right there, were the court to simply follow the Fox case, treble damages arguably would not be permitted. The decision in Fox Supra, however, was based on the decision of the New Jersey Court of Chancery in Kenley Corporation versus Isolitite. The section of our revised statutes on which complainant relies is a relic of the Middle Ages, taken from the Statute of Gloucester, enacted in 1278. Governor Patterson followed the Statute of Gloucester and other ancient English statutes in drafting an act for the prevention of waste, which was passed by our legislature March 17, 1795. His statute has retained a place in our hooks with minor changes, now appears in Title II of our revised statutes as Article 1 of Chapter 79. Later, at page 461, he states, an action of waste on the Statute of Gloucester was already a rarity in Blackstone's day. The usual remedy for waste was an action on the case, a personal action. This was true even though in the action on the case, the recovery was confined to single damages.
Okay, a little bit more. Let me find it.
He nevertheless ruled that so long as the action filed was for a writ of waste, as opposed to a common law suit, the statute was applicable and enforceable. This explains why the federal court in Delaware limited its holding to common law actions. Interestingly, the issue was readdressed by the New Jersey courts in 1954. In 1954, that treble damages were still provided for in suits by landlords for waste by tenants. He pointed out that at the time relevant to the cause of action before him, the statute read differently than its present form. At that time, it provided, any person may have a writ of waste out of chancery against any person holding by dower, courtesy, or otherwise for life, for a term of years or other term, or whoever shall be convicted of waste shall lose the thing or place wasted, and shall be liable in thrice the damages assessed against him by a jury.
Now, so as we can see, Based upon the language of the actual statute, it does not apply to landlords. Once we raise this in the courts in regards to who have the right of reversion remanded as a result of wasteland, as well as a result of what we call descent, disease, or distraint, we have the right to bring a claim for those actions that were done as a result of our past dead ancestors. Okay? We have the right to bring that claim, and that claim is actually being brought based upon the argument raised in this actual court case right here, versus Hanley. Where let's go somewhere else. Let's get another court case to qualify this. Let's get another case law. First of all, what is Anglo-Saxon law? What is Anglo-Saxon law? Let's just get a firsthand of what Anglo-Saxon law is, so we can see who stole it.
Anglo-Saxon law was the legal system of Anglo-Saxon England from the 6th century until the Norman conquest of 1066.
Stop.
It was a
stop. So it says Anglo-Saxon law, which means decree or judgment, was the legal system of Anglo-Saxon England from the 6th century until the Norman conquest of 1066. We know prior to 1066, there was no English feudal baron. It was only English barons of the peerages of England. You got the peerage of Scotland and the peerages of Ireland and whatever other peerage that they got. Different cultures have different peerages or classifications for hereditary titles. When you're dealing with the Anglo-Saxons specifically, before the Norman conquest, or those lords of the manor, or landlords, or manage lords, or tenant chief, which resulted from the so-called distraint going back to the time of William the Conqueror all the way up to the signing of the Magna Carta, which resulted in those 61 royal barons that are still present today, showing based upon the activity of what those barons did in regards to distraint, which is a feudal practice of collecting rent and payment for somebody other than the king. Okay? Very important that we understand that. Continue to read.
It was a form of Germanic law based on unwritten custom known as folk right, and on written laws enacted by kings with the advice of their witan or council.
Stop. Okay. We see New Jersey Provincial Council, His Majesty's Council, then called Department of England, or whatever you want to call it. But prior to that, it was called Witan or Council. When we go back to the 1911 Encyclopedia Britannica, we clearly see that those Witan council holders or wise councils were no other than those Berbers. Okay? Berbers. That ain't Webster's dictionary. That's the 1911 Encyclopedia Britannica saying that. And they said that the rights that were not written down, but were unwritten customs, were known as what, Countess?
That would be known as folk right.
And read the rest of the sentence.
Folk right and on written laws enacted by kings with the advice of the witan or council.
This was also called what? Bookland. It was called Bookland. Real quick.
Bookland was a type of land tenure under Anglo-Saxon law and referred to land that was vested with a charter. Land held without a charter was known as folkland.
All right, hear that. Folkland. You see the distinction? Right. Now check this down. Let us go to United States versus Juan Kimmer, which is a case law in regards to the citizenship of the emancipated slaves during the time of slavery when they were emancipated, and when they were emancipated by the 13th Amendment and became citizens by the 14th Amendment, they inherit their rights under the common law of England based upon English history. That history based upon their origin will be based upon Bookland and not Folkland, because it says Folkland was the land that was held without a charter. That's what it said. So if that is the case, all right, Folkland's a land held with a charter. Let's go to Juan Kimmer and see what they say about that. Because the founding fathers took their rights to inheritance by way of folkland. That's what they said. How I know? Let's look at it. United States versus Juan Kimmer.
Manifestly, when the sovereignty of the crown was thrown off and an independent government established, every rule of the common law and every statute of England obtaining in the colonies in derogation of the principles on which the new government was founded was abrogated. The states, for all national purposes embraced in the Constitution, became one, united under the same sovereign authority and governed by the same laws, but they retained their jurisdiction over all persons and things within their territorial limits, except where surrendered to the general government or restrained by the Constitution, and protection to life, liberty, and property rested primarily with them. So far as the jus commune or folk right relating to the rights of persons was concerned, the colonies regarded it as their birthright and adopted such parts of it as they found applicable to their condition.
Do you hear this? Do you hear this? This is Juan Kim Art telling you what the founding fathers did. They're going to even say even more. Look at what they said.
Okay, they became sovereign and independent states. And when the republic was created, each of the 13 states had its own usages, customs, and common law, while in the respect of the national government, there necessarily was no general, independent, and separate common law of the United States, nor has there ever been. As to the jura corona, including therein the obligation of elite.
That concerns the crown of England, brothers and sisters. Jura corona, the crown.
Including therein the obligation of allegiance, the extent to which these ever were applicable in this country depended on circumstances, and it would seem clear that the rule-making locality of birth, the criterion of citizenship, because creating a permanent tie of allegiance no more survived the American Revolution than the same rule survived the French Revolution.
All right, it's about to get deep. About to get deep. All right, go ahead, right there.
A Chief Justice Cheney observed in Fleming versus Page, though in a different connection, it is true that most of the states have adopted the principles of English jurisprudence so far as it concerns private and individual rights. And when such rights are in question, we habitually refer to the English decisions, not only with respect, but in many cases as authoritative. But in the distribution of political power between the great departments of government, there is such a wide difference between the power conferred on the President of the United States and the authority and sovereignty which belong to the English crown, that it would be altogether unsafe to reason from any supposed resemblance between them, either as regards conquest and war or any other subject where the rights and powers of the executive arm of the government are brought into question. Our own constitution and form of government must be our only guide. And Mr. Lawrence, in his edition of Wheaton, makes this comment. There is, it is believed, as great a difference between the territorial allegiance claimed by an hereditary sovereign on feudal principles and the personal right of citizenship participated in by all the members of the political community, according to American institutions, as there is between the authority and sovereignty of the Queen of England and the power of the American president, and the inapplicability of English precedents is as clear in one case as in the other. The same view with particular application. Oh,
sorry, that's right there. I actually want to come here now. Let me see. Let me find it. Where's it at? Bear with me, Countess. I'm gonna find the part when they overthrow. Oh no, that's not there. That's in the is that Children versus no, it's not Children versus Children. No, it's in this one. Let me just find it. Give me 1 second. We're about to come to our closing as well. Let me find it. Children versus Children. Bear with me. I'll be with you in 1 second. Okay. Actually, it's not. Is this one Kimar? Yeah, United States versus one Kimar. We're about to wrap it up, Count. Just give me 1 second.
Oh, no problem.
Come on. Two bond connects. Okay, here we go. Page 78. All right, here we go. Here we go. This is gonna be funny, y'all.
Yes, okay.
All right, let me see. 1 second. We'll just go to where I need to go. All right, this one. Page 78. All right, here we go. Right here. The framers of the Constitution were familiar.
The framers of the Constitution were familiar with the distinctions between the Roman law and the feudal law, between obligations based on territoriality and those based on the personal and invisible character of origin. And there is nothing to show that, in the matter of nationality, they intended to adhere to principles derived from regal government, which they had just assisted in overthrowing.
Read that again. Read that again. This is United States versus one Kim Ark, the case dealing with the emancipated slave birthright rooted in the English common law and based upon the history of the English people. And they just said they helped assist overthrowing not just the government, but the folk right that they took for themselves as their birthright. All in this one case. Go ahead.
The framers of the Constitution were familiar with the distinctions between the Roman law and the feudal law, between obligations based on territoriality and those based on the personal and invisible character of origin. And there is nothing to show that, in the matter of nationality, they intended to adhere to principles derived from regal government, which they had just assisted in overthrowing.
All right. And they're going to use this word overthrow twice. Watch right here.
Manifestly, when the sovereignty of the crown was thrown off and an independent government established, every rule of the common law and every statute of England obtaining in the colonies in derogation of the principles on which the new government was founded was abrogated.
Now, that's good. So we see that they not only threw off the reaching government, but they also threw off the laws governing that government, i.e. the crown. They admitted it and then took that right for themselves. And we proved that the Majesty's crown was here in 1702 to 1776. So they have just admitted in its case law that they have stolen our birthright, and they have just committed in the other case law that they have committed waste to the land once they stole it. And they use our laws against us by not mentioning the heirs, but mention landlords in place. But the actual statute in regards to the trouble damages as well as the disposition of the land as a result of the waste don't mention landlord, but it mentions heirs. So when we put it in their face, it's going to be detrimental to them. Okay, so in closing, this is what this is really all about: is understanding landlords, land tenures, and landowners. Okay, so with that, let me show the pictures again. Oh yeah, I know what I wanted to show you. This one. The donuts what's it called? What's it called? The Natus Ultras Maurice, the law concerning His Majesty's law in regards to the inheritance of children born abroad. Okay, this is this law. Read this. Also passed by the ancestors, and this actual case is in Juan Kemmer Ark. It mentions that everything you read in here is in United States versus Juan Kemmer Ark. This very statute, De Natis Ultramarines, the Statute of Children Born Abroad Act of 1350, is right there in United States versus Juan Kemmer Ark. And in that case, it says that we have the right to inherit our ancestry's birthright no matter what part of the world we're on. It clearly says it, and they're going to show you in the actual case. Read this for them, Countess.
This ultramare, also known as the Status of Children Born Abroad Act of 1350, was an English statute during the reign of Edward III. It regulated rights of those born overseas and was an early precursor of British nationality law and others. Dating from 1351, during the early part of the 100 Years' War, it addressed the issue of inheritance by foreign-born children, a topical problem.
Do you hear this? So in Juan Kemmer Ark, it actually talks about the children born abroad of descendants of Edward III, based upon the common law of England and the history of the common law of England in regards to those descendants of Edward III, the Plantagenet Angevin king, and his ancestors who have the right to bring claims for waste as well as restraint or deceit when you have taken land that don't belong to you and bring down the property value by way of using it other than the purpose and intent that the king establishes under the adults condition of the bus, as well as Queen Imperatrix. So it's very important. And they mentioned right here the 100-Year War and the first first Barren War, the second Barren War, the third Barren War was all a part of the 100-Year War, my brothers and sisters. So with that being said, this is why we have the Pleading in English Act. Okay? This is why you have the Pleading in English Act. Also passed by who? Edward III. Read this in closing.
The Pleading in English Act 1362, rendered Statute of Pleading, was an act of the Parliament of England. The act complained that because the Norman French language was largely unknown to the common people of England, they had no knowledge of what was being said for or against them in the courts, which used law French. The act therefore stipulated that all pleas which shall be pleaded in any court whatsoever any of his justices whatsoever, or in his other places, or before any of his other ministers whatsoever, or in the courts and places of any other lords whatsoever within the realm, shall be pleaded, sued, defended, answered, debated, and judged in the English language, and that they be entered and enrolled in Latin.
Okay, so as you can see, this is the reason why when we plead to our forefathers, our ancestors, the one we're descended down from, we must understand the language. Okay? Not as foreigners, but as heirs, because the foreigners understand the language and they're using the language as foreigners for themselves. We just proved it. Okay? So in closing, we must understand the difference between estates and lands, okay, and the parcel of estate that you have as an inheritance of the allodial land that belongs to the king. If you're not there to take it, then it automatically falls into what we call inquisition post mortem, meaning it retreats to either the crown or the state under Bala Vacatina, as state versus standard oil company states, as well as state versus Otis Elevator Company state. And in that Otis Elevator Company case, because it says that it would be a grave danger for the state to put themselves in a position as a plaintiff in regards to estates and land. They can do it. They can try to do it with real estate, but they damn sure can't do it with estates and land, because for you to do that, you must be a landlord. And they are not landlords. Hell, they don't even make a claim as landlord. So in that respect, in a chancery court, when I go to my appeal, I don't have nothing to lose because the state of New Jersey never made a claim of the land. This argument in the appellate court is to acquire the title on the allodial land. If you don't have an interest in the land, then you can't raise an argument in regards to who else claims to have an interest in it. So therefore, case is done. So as a result of us understanding estates and land, as well as everything associated with the state and land, that's surface rights, air rights, water rights, as well as those things that come after, which is called real estate, which is this. If you have any real estate on land, then you better make sure when that conveyance, i.e. tenure, land tenure, was conveyed to you, it was conveyed by the landowner and not that landlord. Mm-hmm. If it's not done by the landowner and the landlord, then guess what? You took it by substitution and now violates the laws of the landowner. Okay? Landowner and the landlord is not the same, brothers and sisters. All right? So as a result of that, you have to understand property rights. And that property right is your birthright, your inheritance. Rights and limitations of real property ownership, governing service rights, rights to the air, space above the land, mineral rights, and water rights. All this belongs to you, brothers and sisters. And if you don't take your place amongst the affairs of men and women, you will not be able to regain your lost estate. And I got one more, Countess Middleton, and then we're going to close out. Right here. I'll give
the action.
I'll give you the closing remarks before I close out. All right, go ahead.
Okay, I'll read.
Before you go, this is the case I want to use to support my argument in the appellate court, because this is a 1993 case. Birch versus Hanley was 1991. This is 1993 case, and it's in the appellate court of New Jersey, right where I want to be. Now watch what they say. Where did it go? That's my spot. Here we go. What page is that on? My mouse is acting crazy. More Zillow. Page 7. Okay. Page 7. Way up here. Come on, slow down. I think you are for being patient with your king, and your king will be patient with you. I really appreciate you, Countess Middleton, for taking your time out to assist your king. And for
It's
that,
my pleasure, King.
thank you. And your reward is with me. Where we at? Page 7. Now, look how much they're scared of our church. I'm not going to say it. They're going to say it. They're scared of our church. There we go. All right, you can read.
The actions for defamation.
You hear that? We talk
Develop
about defamation, y'all. Defamation per se. Not just Donald Trump. We can care less about Donald Trump or any other office or corporate officer. We're talking about defamation of a king, the king of the church. Okay? Let's read it.
The actions for defamation developed according to no particular aim or plan. Originally, the common law courts took no jurisdiction, leaving defamatory utterances to be dealt with by the local seigneurial courts.
Stop.
When these
Stop right there. Those seigneurial courts are called lords of the manor courts, or manorial courts or lords of the manor courts. Those are courts set up by these landlords. Okay? Those are courts you go to now. All right? Go ahead.
When these began to fall into decay, the ecclesiastical court stepped in, regarding defamation as a sin and punishing it with penance. As these courts in return lost their power, there was in the 16th century a slow infiltration of tort actions for slander into the common law courts. For a considerable length of time, there were conflicts over jurisdiction between the two sets of tribunals, which led the common law courts to hold that unless temporal damage could be proved, defamation was a spiritual matter, which should be left to the church. When the common, yes, when the common law jurisdiction was once established, an unexpected flood of actions was let loose upon the judges, who seemed to have been annoyed and dismayed by it, and so proceeded to hedge the remedy about with rigid restrictions, some of which survive.
Stop. When the common law jurisdiction was once established, an unexpected flood of actions was let loose upon the judges, who seemed to have been annoyed and dismayed by it, and so proceeded to hedge. What would you do when you hedge something? You restrict it, you block it. All right? They hedge or block the remedy about with rigid restrictions, some of which survive today. That's about to stop right now because what they're saying they're doing, that's what the appellate court was doing. I mean, the chancery court did, the law division did, as well as the criminal court did. They were offended by the common law defamation per se character that they have done against your king. And now it's coming back to hunt them. Continue.
The reluctance with which the common law courts at first received the action of slander.
I'm sorry. I went too far. This mouse got a mind of his own. Okay, here we go.
Okay. The reluctance with which the common law courts at first received the action of slander and their fear of invading the province of ecclesiastical law led them to hold that the action would not lie without proof of temporal damage. From this there developed the rule that slander in general is not actionable unless actual damage is proved. To this, the courts very early established certain specific exceptions: the imputation of crime, of a loathsome disease, and those affecting the plaintiffs in his business, trade, profession, office, or calling which required no proof of damage.
Stop.
The exact.
So that's defamation per se, meaning that when you lie, slander, or defame somebody as a result of their business, trade, profession, office, or calling, then it does not require proof to meet the standard of defamation per se. Okay? And this has to do with the church, which they're trying to avoid. Okay? Under the common law of England. So with that, we must truly understand that as Englishmen and women, as members of the English church, and as heirs of this illustrious estate, we are being defamed. So in order to restore that, you must protect your king. All right? Because when I'm hurting, you're hurting. And with that, we're going to digress with these marvelous lessons. I'm going to let Countess Middleton say a couple of words, and then I'll close out. You got the floor, Countess.
Well, it's very, I'm looking at this whole scene from a very astrological perspective. And, the first defamation of character happened around that same time, the Revolutionary War, which is King George III.
You're breaking up. Speak a little closer to the mic.
Oh, King George III was one of the first causes of defamation of character in terms of what he was accused of, according to the royal colonies.
Yes.
Now, at the time that he was reigning, a new planet was discovered. They actually called it George's star, which was the planet Uranus, okay, which is also associated with rebellion and with revolution. And so, but the energy of this planet is being looked at again in this time period. And also, King, you came in terms of how I discovered you. This time period is part of this time of what they call Pluto. The Pluto is in Capricorn, which is the sign of government.
That's my
So
son.
again, major transformation, major changes, that things have to be looked at. Pluto is a planet of judgment. So this is the time of judgment. And again, what you're addressing is again very timely. And we see it. It's like a natural reflection. We don't have to work that hard. So the defamation of king is being recircled now because again, it's been accused of being all of these things that had nothing to do with it. Was it a media game? I don't know. It sounds like that to me. Something was put in place to accuse and almost try to bring down a government. And I digress.
Well said. And like I said, this is the reason why I said that the accounts or the records or the stories that were told by those who wrote our story was simply a play that's being played out before our eyes in the present day. So when they did all those theatrical plays in King James, you can take it all the way back to Thor. You know what I'm saying? All of it was theatrical in that respect, of describing the events that they were going to usher in for those that they were describing in the storytelling that were told were myth, folklore, etc., not realizing that it was our actual story. And as I say again, he who writes your books set your timeline. Time never was when we were not. As the life of time began, the time will come when we will be no more. So once again, I thank you, Countess Middleton, for your assistance. You read very well, very passionately, as well as diligently. And I rest assured that all of you must meet or come up and make that measurement, okay? Each and of your own. So much courage for what to say, for what's that saying? For great responsibility is given. How that goes? From great power come from, how that go? From great power comes great responsibility. Something to that effect. You know what I'm saying? So I understand, and I'm pleased to be in this position because I'm a hermit. I stay home. You know, I don't eat. I can live off the spirit for 2 or 3 days. You know what I'm saying? And I realized that, like, wow, I'm actually being divinely guided. You know what I'm saying? And No, even when I'm discouraged in the physical, I'm assured in the spiritual that I'm on the right path. And the evidence is what I presented today. But there's no one out there doing this. So with that, thank you, Countess Middleton. Thank you all for showing up today. And please, please study yourself. And with that, we here at the Third Tipping Church of England say peace.
Thank you, King.
Anytime, Countess Middleton. I look forward to you dialoguing with you again. So have your phone on dialogue. There might be a part 2 to this. I'm not sure. But I
Okay.
took it on the responsibility of my grandson. So I'm pretty much sorted out. But it's just beautiful to just do what we need to do for family. You know what I'm saying? For family.
Yes,
So once again,
absolutely.
I'm about to take it down. Thank you all for coming. We'll talk to you later.
Peace.
Peace. I'll close this out.